following commissioners: Jeffrey A. Hughes, Floyd B. McKissick Jr., William M. Brawley, Tommy Tucker, and Stephen J. Levitas. In compliance with the State Government Ethics Act, I remind members of the commission of their duty to avoid conflicts of interest and inquire as to whether any member of the commission has a known conflict of interest with respect to any matters coming before the commission this morning. Let the record reflect that no such conflicts have been identified. So we will proceed with public staff item number 1.
Good morning, commissioners. My name is Caleb Hill, engineer with the Public Staff Energy Division. I do want to make a note on the agenda. It lists Hill, Keyworth, and Puglisi, Johnson, and Bernier. For presenting this item, it will just be myself and Keyworth. Item 1 is a joint request filed by Duke Energy Progress, LLC, DEP, and Scotch Grove Solar, LLC, Scotch Grove, to transfer the certificate of public convenience and necessity for an 80 megawatt AC solar facility located in Scotland County, North Carolina, from Scotch Grove to DEP. Contemporaneously with the application, DEP filed a registration statement for a new clean energy facility. The facility was selected in the 2023 Solar and Solar Plus Storage competitive procurement. The public staff has reviewed the application and recommends the commission grant the transfer request and accept the registration statement as outlined in the proposed order with the commission staff's red line version edits and one small correction to the red line edits. Reference was made to Rule R8611. That should be Rule R861.
And could you identify where that additional correction is so that we can be clear about that?
Yes, that's in paragraph 1 by the commission. I believe it's the second or third sentence, about the middle of the paragraph.
Chair come right. That was already corrected before we circulated it.
Okay, thank you.
Okay.
I'll move for approval with the version we have, which includes the correction.
Second.
Okay. We have a motion and a second. Are there any questions or discussion? Commissioner Tucker.
Yes, ma'am. Thank you, Madam Chair. Answer a question for me. You know, there's supposed to be a 55-45 split, as I understand it, with solar, with Duke owning 55%. What does this transfer skew that percentage? I mean, you know, if things were, you know, economy, whatever, and they wanted the solar developers or the solar owners wanted to sell to Duke, does this skew that at all as these go through the process? I mean, I hope that's a fair question. It's for my own edification. Thank you, sir. Go ahead.
Yeah, absolutely. So the way that the RFP is designed, it has that 45-55% split baked into it. They're procuring both power purchase agreements and solar owned, utility owned facilities. And so they, when they do that procurement, they have 2 different buckets. They have the PPA track and the utility owned track, and they have that 45% of all the solar, so that they have the facilities that are bid in, and they'll split it between the 2 tracks, and the facilities are able to bid into either track. And then so Duke on the back end does that splitting to make sure that they have that balance between the 2.
Okay, so I should have asked my peer here, commissioner to my left, who's been involved in this a lot in his career, for the explanation. I just want to know how that skews. Does this put them over 55? Are they under 55% when they're purchasing these? Who checks that? Who responds to that? I guess Duke keeps that with it. Public staff does as well, so that they don't go over what's set up in the statute.
That's a good question. I don't know the answer to that. There is representatives from Duke that might be able to answer that question a little bit better for you.
Okay, and I also see a representative of the public staff coming up as well. If you...
Good morning, commissioners. This is Jeff Thomas with the public staff. I'm familiar with this case and the RFP. So this transfer is, as Mr. Hill was describing, is part of the projects needed to be acquired by the utility as part of the 55% ownership.
Okay.
So it doesn't skew it. It's kind of baked in. And this one, if because the utility does both self-develop and purchase them. So this is all part of that 55.
Okay, thank you, Jeff. Thank you, Madam Chair.
Okay. Thank you, Mr. Thomas. Is there any additional questions or discussion? Commissioner Levitas?
So I gather it's the case that with respect to the Duke-owned assets, that those are being owned by the company itself and not through a wholly owned subsidiary, because in this case, they could have just acquired the LLC. Is there any rationale behind that or any pros and cons of doing it one way or the other? And somebody from Duke may have an answer to that.
Yeah, maybe it is owned by the company, not a subsidiary, but the company may be able to respond to questions whether that's good or bad, but they've typically, historically been owned by the company.
And I see a representative of Duke coming forward as well.
Good morning, Commissioners. We have Justin LaRoche and Maura Farber available to answer questions. Maybe Justin. And sorry, Jason Higginbotham on behalf of Duke.
Morning, Justin LaRoche on behalf of the applicant. So the assets are owned and operated as the regulated utility LLC, as opposed to acquiring the project company and then having a laundry list of different LLCs owning the fleet of solar facilities. We do not do that. We do an asset purchase agreement and acquire all of the rights and assets by the third-party developer, and then it's owned, operated, executed as Duke Energy Progress LLC.
Okay, thank you.
Okay, we have a motion and a second, and the motion includes the edits in the current version before the commission. All in favor? Aye. Any opposed? The motion carries. Thank you all for answering the questions.
Thank you.
So we will proceed with public staff item number 2.
Good morning. I'm Lindsay Darden, engineer with the Public Staff Water, Sewer, Transportation, and Telephone Division. Without objection, I'll be presenting items numbers 2 through 6 together today. In docket numbers W-218 sub 582, 589, 590, 605, and 619, Aqua filed notifications of intention to begin operations in areas contiguous to present service areas to provide water utility service to service areas in North Carolina. The public staff recommends that the commission issue the proposed orders, recognizing the contiguous extensions and approving rates.
I'll move approval.
Second, I do have 1 or 2 questions.
Okay, so we have a motion and a second. Question from Commissioner McKissick.
Yeah, and this is in regard to item number 6. And that's the gallons per minute, which the additional well is providing it. I gather DEQ has a standards around, basically about half of what the public staff usually seeks in terms of 1 gallon per minute. And even with the combined well capacities, with an existing well, it's still falling down, as I recall, about 9/10 as opposed to being up that 1 gallon per minute. I guess the question is twofold. First, when we see these types of discrepancies taking place, how often is it that public staff would go in and say, let's make this kind of exception, for the public good, public interest? And then secondly, if we find it is inadequate in terms of the water that's being generated from the combined wells to satisfy the demands in the subdivision, what tool is open to the public staff at that time to ask Aqua to come in and do something to rectify that problem, since we know there's likely to be problems longer term based upon the order and what's the report the public staff's provided?
Well, for the first part, as far as how often we make the exceptions, we do have to look at all of these on a case-by-case basis. So for this particular one, since this contiguous extension is interconnecting with other wells, although they're not meeting that exact 1 gallon per minute, I think they're meeting it's 0.91. So they're fairly close, but they also have this security since it's not just a one well system, it's going to be a 3-well system. That gives you a little bit more flexibility with the well capacity and meeting demand. Another issue with this particular one was originally Lange Ridge Estates was being developed by a different utility. So there was a level of control that Aqua didn't have from the very beginning with the developer and working with that and developing that well. So that was taken into consideration too. As far as tools that the public staff has, there's definitely operational tools that Aqua can use as far as pump sizing and potentially down the road if they had to add a well for capacity issues. But that's something that I think would be working more informally with the company as far as how the public staff would address that.
And would that type of option be pursued in the event there were complaints coming from people that were customers, or would that be kind of self-initiated as part of an annual review or some type of periodic review?
Complaints is usually how the public staff is aware of there being issues with capacity as far as pressure or demand issues. Again, because the standard is higher than how DEQ sets, it's typically dependent too on the location. If it's a high irrigating community, that's a factor too of how much the demand is. So it's that's again why it's a case-by-case basis. It kind of depends on the usage of that particular service area.
So assuming there were complaints that came in that public staff was aware of, you would at that point in time have conversations with Aqua to determine whether it's best to say, put in new pumps at the well or build additional wells, but they would be addressed at that time. There wouldn't be any issues or problems in addressing it in the event there was a deficiency determined.
Yes.
Okay. Thank you.
Commissioner Tucker.
Thank you again, Madam Chair. I'll try to be expedite this pretty quickly. Got one question for Ms. Darden and then one for Aqua, and I see a representative from Aqua here. They can come up. Ever since I've been here, I never have understood the public staff's rationale on bonding. You've got 3 here at 25,000 and 2 here at 10,000 with the same company. And I understand we got a long relationship. They're investor owned, et cetera. Well, once again, can you give me an oversimplified formula of why you choose what for what bond? Some are 75,000, some are 100.
Right. I can't give you a formula because there's not a particular formula that we follow. There's the criteria that we look at, again, on a case-by-case basis. For these particular ones, the 2 items that we felt that a 10,000 bond was more appropriate. One of the contiguous extensions was for 3 customers, and the other contiguous extension was for 6 customers. So those we felt didn't require that same 25 that is typical standard. Another factor for that too, it's not, and I don't want to present it as it's just the number of customers. Aqua also has over $13 million of available bond. So that's a factor too in how we felt that we could go a little lower for those 2 items because there is still that over 13 million available bonds from the company.
Okay. All right. I want to ask that question again. I would ask Aqua if they'd come up, Madam Chair, and answer one question about their business model.
Good morning, Ruffin Poole with Aqua.
Okay, thank you. Ruffin, Mr. Poole, help me here. You're taking on, like in item number 2, serves 12 water customers and expects to eventually serve 21 customers in the Viking. I don't see the volume and the expense of owning a system or whatever. Help me on, is there a contiguous development that's going to have a plethora of customers for you guys? I just don't understand how you make the economics work. Just humor me, if you will, and just tell me about that.
That's fine. I believe you're referring to Viking Ridge in this particular case.
Yes.
So Viking Ridge is basically a contiguous extension to an existing subdivision development called, the water system's called Sterling Sterling Shire East or Sterling Shire in Guilford County. This was a system that the original developer had plans to do it another phase, was hit during the economic downturn, and then another developer picked it up probably 15 or 20 years later, and then exercised that ability to build those additional lots. So it had been previously planned, just not executed by the original developer.
Okay.
So there was sufficient capacity to support the extension to add those additional 20-some customers.
Share with me about Bowview Estates.
Yes, sir. That's within Elbow Country Club in Allegheny County.
Contiguous to another development?
Yes, sir.
Because you only have 3 customers there.
That's correct. Yes,
Okay,
sir.
I get it. I get it. Okay, thank you, sir. I appreciate your answer. Thank you, Madam Chair.
Okay. So we have a motion and a second to approve public staff items 2, 3, 4, 5, and 6. All in favor? Aye. Any opposed? The motion carries, and thank you, Ms. Darden, for presenting these items. We will now move on to public staff item 7.
Still me. Item number 7 is docket number W-1305 sub 44. Claris Hampstead filed a notification of intention to begin operations in an area contiguous to a present service area to provide wastewater utility service to the Pender County Farm Bureau office in Pender County, North Carolina. The public staff recommends that the commission issue the proposed order recognizing the contiguous extension and approving rates.
Move approval.
Second.
Okay, we have a motion and a second. Are there any questions or discussion? Okay, seeing none, all in favor?
Aye.
Any opposed? The motion carries. So public staff item number 8, is that you again, Ms.
Yes,
Darden?
I'll finish this out today.
Okay,
Item number 8 is docket number W-218 sub 628. Aqua filed a petition to amend its tariff for the purpose of passing along to its water customers in 18 subdivisions in Cumberland County, North Carolina, an increase in the cost of purchasing water service from Fayetteville Public Works Commission. The public staff recommends that the commission issue the proposed order approving the tariff revision and requiring customer notice.
I'll move approval.
Second.
okay, we have a motion and a second. Any questions or discussion? Okay, all in favor?
Aye.
Any opposed? The motion carries for public staff item number 8. And now we will move on to the last one, public staff item 9.
Item number 9 is docket number W-1331 sub 3. Royal Gorge Water Utility filed a petition to amend its tariff for the purpose of passing along to its wastewater customers an increase in the cost of purchasing wastewater utility service from the Metropolitan Sewerage District of Buncombe County in Buncombe County, North Carolina. The public staff recommends that the commission issue the proposed order approving the tariff revision and requiring customer notice.
I'll move approval.
Second.
We have a motion, a second. Any questions or discussion? All in favor? Aye. Any opposed? The motion carries. Thank you, Ms. Darden. So we now have before us the minutes of the March 31st, 2025 staff conference for approval.
Approval adopt the minutes as presented.
Second.
Okay, we have a motion, a second. All in favor?
Aye.
Any opposed? The minutes are approved. And is there any additional business for the commission this morning? And Ms. Holt, I believe you have some, a new attorney that you would like to introduce.
Good morning, Commissioners. I'm Gina Holt, Manager with Public Staff Legal Division. And I'm happy to introduce today the Public Staff's newest addition to the Legal Division, Malind Dongre.
Good morning.
Malind has over 13 years of legal experience, including significant litigation and appellate experience. He comes to us from the North Carolina Department of Justice, where he provided legal and policy advice and litigation services related to North Carolina Medicaid to the Department of Health and Human Services. Malind is married and has 2 boys, ages 7 and 10, and he will be working on all matters except electric.
Good morning. It's nice to meet you all, and I'm glad to be here.
Yes, well, we appreciate you being here and taking the position with the public staff. I think your litigation experience will be very helpful to the public staff, and we look forward to working with you on behalf of the commission. So thank you for being here.
Likewise, look forward to working with you all. Thank you.
Is there any additional business for the commission? Okay, seeing none, with that, we'll be adjourned.